My wife of 44 years had been gone for exactly 11 days when I watched my daughter-in-law smile at her funeral trust meeting. And I want you to understand something before I tell you what happened next. I've spent 38 years on the federal bench, first as a trial attorney and then as a judge, reading the faces of people who had every reason in the world to lie to me. I have watched grown men weep real tears over fraud they orchestrated themselves, and I have watched genuinely innocent people fall apart under the simple weight of being falsely accused. You learn, after 4 decades of that work, exactly what a real smile looks like next to a rehearsed one. And the smile Christine gave when our family attorney read the words, "The remainder of the estate to be distributed as amended," was not the smile of a grieving daughter-in-law. It was the smile of someone who had been waiting a very long time for exactly that sentence. My name is Harold Bennett. Everyone who's known me more than a week calls me Hal. I'm 71 years old, and for most of my adult life I sat in courtrooms trying to sort truth from performance for a living. But nothing in 38 years on the bench prepared me for what I discovered in the weeks after my wife Margaret passed away. And I need to tell this story from the beginning, because the ending doesn't mean anything if you don't understand what we lost to get there. Maggie and I met in the fall of 1980. At a law school mixer neither of us particularly wanted to attend. She was finishing her master's in social work, sharp-tongued and unimpressed by every young lawyer trying to charm her, and I fell for her within about 20 minutes of her telling me, quite bluntly, that most attorneys she'd met cared more about winning than about justice, and she wasn't sure yet which category I fell into. I spent the better part of the next 6 months trying to prove to her I belonged in the second category, showing up at the legal aid clinic where she volunteered on weekends, offering to help with cases that paid nothing and demanded everything, just to spend a few more hours in her presence. She told me years later on our 20th anniversary that she'd made up her mind about me within the first month, but let me keep showing up for 5 more just to make sure I meant it. We married 2 years later, in a small ceremony in her parents' backyard, with folding chairs borrowed from the church down the street and a cake her mother baked herself because we couldn't afford a proper bakery order on a first-year associate's salary and a social worker's stipend. Maggie wore her own mother's dress, taken in at the waist, and I remember standing at the front of that yard, watching her walk toward me and thinking, with a certainty I have never once doubted in the 44 years since, that I had somehow talked the sharpest, kindest, most fundamentally decent person I would ever meet into spending her life with me. We raised our son Michael in a modest brick house I still live in today, and for 44 years, through 3 decades of my career on the bench and her 30 years running a non-profit legal aid clinic for low-income families, Maggie was the steadiest, sharpest, most fundamentally decent person I have ever known. She never once let my career pull rank over her own work, even when my salary as a federal judge would have made it easy for her to step back and not have to fight the city council every budget cycle for enough funding to keep her clinic's doors open. She fought for that clinic the same way she fought for everything she loved, quietly, relentlessly, without ever once asking anyone's permission to care as much as she did. I think about our life together constantly now, the ordinary parts most of all. The way she read the newspaper out loud to me over coffee every single morning for 4 decades, offering commentary I usually disagreed with, just to keep the conversation going. The way she kept a small, dog-eared notebook of every client's name she'd ever helped at the clinic, insisting she owed it to each of them to remember, even the ones whose cases she'd lost. The particular, exasperated affection in her voice every time I brought home yet another stack of case files, instead of coming straight home for dinner. 44 years is a very long time to build a life with someone, and I did not understand, until I was faced with the possibility of losing every piece of what we'd built being systematically stripped away after her death. Just how much of my own identity had grown into hers over those decades. 3 years before she passed, Maggie was diagnosed with early-onset Alzheimer's. She was 66 years old. I remember the exact words the neurologist used, and I remember Maggie's response even more clearly because it was so completely her. She looked at that doctor, still sharp enough at that moment to fully understand what he was telling her, and said, "Well, I suppose I'd better get my affairs in order while I still remember what they are." That was Maggie. Even facing the slow erosion of her own mind, her first instinct was practical, protective, thinking of the people she'd leave behind rather than herself. For the first year and a half after the diagnosis, we managed largely on our own, with help from a wonderful home health aide 3 days a week. Michael, our son, had married Christine 4 years earlier, and in that first stretch after Maggie's diagnosis, Christine inserted herself into our lives with what I genuinely believed, at the time, was generous, loving concern. She started coming by twice a week to help with meals. She took over managing Maggie's medical appointments, her medication schedule, eventually her finances, gently insisting it would be easier for everyone if she just handled the details, so Michael and I could focus on simply being present with Maggie emotionally. I want to be honest with you. I welcome that help. I was still working part-time as a senior judge, handling appellate cases, exhausted in a way I'd never experienced in my life, watching the woman I loved slowly lose pieces of herself. And when Christine offered to take administrative burdens off my shoulders, I said yes without the scrutiny I would have applied to literally any other party, appearing before my bench, asking for that much control over a vulnerable person's affairs. That is the single greatest regret of my life, and I will carry it for whatever years I have left. By the second year, Maggie's decline had accelerated faster than her doctors initially predicted. Christine suggested, gently but persistently, that a specialized memory care facility might provide better daily support than we could manage at home, particularly given my own health, which had never been an actual concern, but which Christine mentioned often enough that I eventually started to believe it myself. We moved Maggie into Willowbrook Senior Living 18 months before she passed, a decision I made in consultation with Christine, trusting her research into the facility's reputation completely. I visited Maggie almost every single day at Willowbrook. I want that on the record clearly, because everything I'm about to tell you might make you wonder whether I was simply an absent husband who missed obvious warning signs. I was there constantly, but Christine had positioned herself over those 18 months as the primary point of contact for Maggie's care team. Her medications, her financial arrangements, and eventually, quietly, as the person managing something I didn't even know was happening until it was almost too late. Updates to Maggie's estate planning documents, executed during periods when Maggie's competency was, at best, deeply questionable. Maggie passed away on a Tuesday morning in early spring, peacefully in her sleep at Willowbrook. I was holding her hand when the nurse came in to check her vitals for the last time. Looking back now, I can identify at least half a dozen moments during those 18 months at Willowbrook that should have troubled me far more than they did at the time. There was the afternoon, roughly a year before she passed, when I arrived for my daily visit to find Maggie unusually agitated, insisting she needed to find the papers before Christine comes back, though when I gently asked what papers she meant, she couldn't articulate it clearly, and a nurse nearby suggested it was likely just confusion, a common symptom of her disease's progression. I believed that explanation completely at the time. I've thought about that afternoon almost every day since. There was the period, about 8 months before her death, when Christine began gently suggesting that my visits, while wonderful for Maggie emotionally, were sometimes overstimulating during her more agitated phases, and that perhaps shorter, more structured visits, scheduled around Christine's own visits rather than freely, as I'd always done, might be easier on Maggie's nervous system. I agreed, because it was framed entirely around Maggie's well-being, and because by that point I trusted Christine's judgment on caregiving matters almost as completely as I trusted my own. I did not fully register until Priya's investigation months later laid it out in a stark timeline. That this restructuring of my visiting schedule had begun almost exactly when Christine's financial transfers from Maggie's accounts had started accelerating in frequency. There was the time, perhaps 5 months before Maggie died, when I noticed a stack of documents on the small desk in her Willowbrook room. Official-looking papers with a signature line at the bottom that I didn't recognize. And when I asked Christine about them during a visit, she told me easily and without hesitation that they were simply routine updates to Maggie's medical care directives, required periodically by the facility. Nothing I needed to worry myself over, given everything else on my plate. I did not ask to see them more closely. I trusted her. That single moment of trust, I would later learn, was very likely the moment I unknowingly witnessed the earliest draft of what would become the fraudulent trust amendment, sitting in plain sight on my dying wife's desk, and I walked right past it because I had no reason yet to imagine what it truly was. The funeral was held 4 days after Maggie passed, at the same small church where our friends had gathered for her retirement celebration from the legal aid clinic 6 years earlier. Nearly 200 people came, former clients she'd represented decades ago, colleagues, judges I'd served alongside, neighbors who'd known her for 40 years. Michael delivered the eulogy, his voice breaking twice, describing his mother as the only person I've ever known who could make you feel like you were the most important case on her desk, even when you were just asking her to help you find your car keys. I remember very little of what I said myself that day, only that I stood at that podium and found myself, for the first time in my life, completely unable to find the right words, a feeling entirely foreign to a man who had spent decades commanding courtrooms with careful, deliberate language. Christine sat in the front pew beside Michael throughout the service, dressed appropriately, dabbing at her eyes with a tissue at what seemed, at the time, like all the right moments. I remember thinking even then, in the depths of my own grief, that she seemed remarkably composed for someone who had spent the better part of 2 years serving as Maggie's closest daily caregiver. I did not think anything more of it than a passing observation. Grief manifests differently in everyone, and I had no reason yet to read anything into the particular quality of her composure. 11 days later, our family gathered in the conference room of Whitmore and Associates, the estate attorney's office Christine had recommended we use 2 years earlier, to review the trust and estate documents. Michael sat beside Christine. Our granddaughter Emily, 9 years old, stayed home with a babysitter, thankfully. Grace, my late wife's younger sister, sat across from me, still red-eyed from the funeral. Our longtime family friend and Maggie's former legal aid colleague, Denise Alvarez, sat beside me at my request, since I trusted her judgment completely and wanted a second set of eyes on documents I was still too raw with grief to fully absorb. The attorney, a soft-spoken man named Gregory Whitmore, began reading through the trust. For the first several minutes, everything sounded exactly as Maggie and I had planned it together years earlier, before her diagnosis. Back when we sat down with our original attorney and structured our estate with careful, deliberate fairness, the house to me for my lifetime use, then to Michael, specific sentimental items distributed to Grace and to close friends. A modest scholarship fund Maggie had insisted on establishing in her own mother's name for first-generation social work students, and the remainder of our combined estate, roughly $18 million, built primarily through decades of careful investment and my own family's original manufacturing business, is split evenly between Michael and a trust for Emily's education and future. Then, Whitmore reached a section I did not recognize, an amendment dated 14 months earlier, restructuring the distribution significantly. Under the amended terms, Christine, not Michael, was named as the primary trustee of nearly the entire estate, with broad, largely unsupervised discretion over disbursements, including her own compensation as trustee. set at a rate that would generate several $100,000 annually, regardless of how the underlying assets performed. Michael's direct inheritance had been restructured into a much smaller, restricted allowance, requiring Christine's approval for any distribution above a modest monthly amount. My own lifetime use of the house remained technically, but was now subject to reasonable maintenance contributions to be assessed and collected by the trustee, meaning Christine. I sat very still while Whitmore read through those terms. The same stillness I used to hold on the bench when an attorney tried something audacious in my courtroom, and I needed a moment to decide exactly how I was going to respond. And in that stillness, I watched Christine's face out of the corner of my eye. She was smiling, not broadly, not obviously enough for anyone, not specifically watching for it to notice. Just a small, satisfied curve at the corner of her mouth, the kind of expression you allow yourself when a plan you've worked on for a very long time finally lands exactly where you intended it to. Michael beside her looked confused rather than pleased, glancing between the document and his wife with an expression I recognized from his childhood. The look he used to get when he suspected something wasn't quite adding up, but couldn't yet articulate what. I did not say anything in that meeting. 38 years on the bench taught me that the worst possible moment to reveal what you know is the exact moment you first realize you know it. I thanked Whitmore for his time, told the family I needed a few days to process everything, and drove home alone. My hands steady on the wheel, even though everything inside me had gone cold and sharp, with a clarity I hadn't felt since Maggie's diagnosis 3 years earlier. Denise called me that evening. She'd been quiet during the meeting, but I could tell from her voice on the phone that she'd been running the same calculations I had. "Hal," she said, "I need you to tell me honestly. Do you remember Maggie ever discussing restructuring the trust like that? Naming Christine as primary trustee with that kind of discretionary authority?" I told her no. Maggie and I had discussed our estate plan extensively before her diagnosis, and even in the early stages afterward, while she still had good days, clear days. We talked about it more than once. She had never once expressed any intention of shifting that much control to Christine specifically. If anything, in her more lucid moments during the first year after diagnosis, Maggie had expressed a growing, quiet unease about how quickly Christine had inserted herself into every corner of our lives. 14 months ago, Denise said slowly, was right around the time Maggie's condition had progressed to the point where her care team documented significant cognitive impairment in her medical records. I remember visiting her that spring, Hal. She barely recognized me some days. I don't understand how she would have had the capacity to knowingly execute a document that complex. That question became the thread I pulled for the next several weeks, and everything unraveled from it. I called my old law clerk, a woman named Priya Nataraj, who had clerked for me for 2 years in the early 2000s and had since built a formidable private practice specializing in elder law and estate litigation. I trusted her judgment more than almost anyone I'd worked with in my career, and when I explained what I'd seen in that reading, she didn't hesitate. "Judge Bennett," she said, still calling me that out of old habit even years after I'd retired, "I want to be very careful here, because accusing a family member of elder financial abuse is one of the most serious things you can put in motion, and it will change your family permanently, whether or not it's ultimately proven true. Are you certain you want to go down this road?" I told her I had spent nearly 4 decades demanding evidence before conclusions from every attorney who ever stood in front of my bench, and I intended to hold myself to exactly the same standard now. I wasn't going to accuse anyone of anything. I was going to find out what actually happened. Priya started as any good attorney would, with the paper trail. She requested certified copies of the trust amendment from Whitmore's office, along with the notary records associated with its execution. What she found troubled her immediately. The amendment had been notarized, not by the notary Whitmore's office typically used for estate documents, but by an outside notary named Carl Denning. whose registered business address turned out to be a shared co-working space with no permanent staff, and whose notary commission, on closer inspection of state records, had actually lapsed 4 months before the date printed on Maggie's amendment. That alone could be enough to challenge the document's validity, Priya told me during our second meeting. But I want more than a technicality. I want to understand whether your wife was actually capable of understanding what she was signing that day. Because if she wasn't, this isn't just a paperwork problem. This is fraud. Before Priya's investigation reached its later, more damning findings, there was a week I want to describe. Because it was, in some ways, the hardest week of the entire process. Harder even than the courtroom. Priya suggested that before we filed anything formally, I should return to Willowbrook myself quietly and speak directly with the nursing staff who had cared for Maggie in her final months, off the record, simply as a grieving husband asking questions rather than as the lead petitioner in a fraud investigation. She believed people tell a widower things they'd never say to an attorney with a subpoena. She was right. I spent 4 afternoons that week sitting in Willowbrook's small visitor lounge, the same worn armchairs where I'd once read the newspaper aloud to Maggie the way she used to read it to me, speaking quietly with aides and nurses who had known her during those final 18 months. Most of what I heard was simply confirmation of what we already suspected, offered hesitantly, apologetically, by staff clearly uneasy about speaking ill of a family member, even when they suspected something wasn't right. One aide, a soft-spoken young woman named Priscilla, who had worked the evening shift on Maggie's floor for nearly 2 years, told me something that has stayed with me since. Mrs. Bennett used to ask me, some evenings when she was having a clearer night, whether I thought her family really understood what she wanted, Priscilla said, twisting a tissue in her hands as she spoke. I always told her of course they did, because what else do you say to a resident who's frightened and confused? I wish now I'd asked her what she meant, instead of just reassuring her. I think about that a lot, honestly, Mr. Bennett. I'm sorry. I told Priscilla she had nothing to apologize for, that the failure here belonged entirely to the people who had exploited Maggie's vulnerability, not to overworked staff doing their best in an understaffed facility. But I understood, sitting in that lounge, why Priya had wanted me to hear these things directly, rather than through a formal deposition transcript. The paperwork Rosalind and Priya were building told the story in numbers and dates. The staff at Willowbrook told it in something closer to grief, the particular, helpless grief of people who had cared for Maggie daily and sensed something was wrong without ever having the authority or the full picture to act on it. Another nurse, an older woman named Dolores, who had since transferred to a different facility, agreed to speak with Priya's investigator formally once she understood the scope of what was being alleged. She confirmed that Christine had, on several documented occasions, specifically requested that certain medication administration notes be logged before the medication was actually given, citing her own busy schedule and insisting it was simply more efficient for everyone. Dolores said she'd raised the concern informally with a shift supervisor at the time and been told the facility was too short-staffed to police every family member's preferences, an answer that, months later, would become a central piece of evidence in the state's broader licensing investigation. Into Willowbrook itself, we requested Maggie's complete medical records from Willowbrook, covering the 6 weeks surrounding the amendment's execution date. What we found broke my heart in a way I wasn't fully prepared for, even after everything. The facility's own clinical notes from that exact window described Maggie as experiencing significant confusion, difficulty with short-term recall, and periods of disorientation regarding time and place, standard documentation for the ongoing progression of her disease. On the specific date the amendment was supposedly executed, the nursing notes indicated Maggie had been given her evening medication, including a sedative she'd recently been prescribed for agitation, roughly 90 minutes before the notarization was recorded as having taken place at 4 in the afternoon. Hal, Priya said, sliding the timeline across her desk toward me. Either the nursing staff documentation is wrong, or your wife was sedated within an hour and a half of supposedly making complex, legally binding decisions about an $18 million estate, in the presence of a notary whose commission had already expired. Neither one of those possibilities is good for whoever orchestrated this. I sat in Priya's office that afternoon and felt something I hadn't allowed myself to feel since Maggie's diagnosis 3 years earlier, a specific, focused, controlled fury, the kind I used to feel on the rare occasions I discovered an attorney had deliberately misled my court. Except this wasn't a courtroom, and the person being deceived and exploited had been my wife, in the most vulnerable state of her entire life. Priya suggested we bring in a forensic accountant to trace the financial side of things while she continued building the legal challenge to the amendment itself. The accountant she recommended, a meticulous woman named Rosalind Chu, spent nearly a month combing through Maggie's accounts, the trust's investment records, and Christine's own financial history over the previous 3 years. What she found layered an entirely new dimension of betrayal onto what we already knew, beginning almost exactly when Christine took over managing Maggie's day-to-day finances. Roughly 2.5 years earlier, a pattern emerged of gradually increasing transfers, disguised as reimbursements for caregiving expenses, medical supplies, and facility co-payments, routed from Maggie's personal checking account into an account Christine controlled independently. Individually, most of the transfers were modest enough to avoid obvious scrutiny. A few $100 here, 1,000 there. Cumulatively, over 2.5 years, they totaled just over $340,000, alongside receipts and documentation that, when Rosalind cross-referenced them against Willowbrook's actual billing records, simply did not match what the facility had ever charged us for. This is a fairly classic pattern in elder financial exploitation cases, Rosalind explained during a meeting in Priya's conference room, spreading spreadsheets across the table with the same careful precision I imagined she brought to every case. Small, defensible-looking transactions that individually raise no red flags, but that accumulate into significant unauthorized transfers over time, combined with the trust amendment naming her as primary trustee with broad discretionary authority. This looks less like a single bad decision and more like a sustained, patient strategy. There was one more piece, the piece that finally broke something loose in me that had been holding steady through everything else. Rosalind's review of Willowbrook's internal staffing and medication administration logs, obtained through a records request Priya filed on the grounds of the ongoing fraud investigation, revealed a troubling pattern in the final 4 months of Maggie's life. Multiple documented instances where scheduled doses of Maggie's heart medication and a critical blood pressure prescription were recorded as administered in the facility's official log, but where the corresponding medication inventory counts, tracked separately by the pharmacy that supplied Willowbrook, did not match. In plain terms, the paperwork said Maggie received her medication. The actual pill count suggested in several instances that she hadn't. We brought this specific finding to a physician Priya retained as an independent medical expert, a geriatric specialist named Dr. Amara Osei, who reviewed Maggie's complete medical file, including the medication discrepancies. Over the course of 2 weeks, I want to be careful about how I say this, Dr. Osei told us, sitting across from me with a gentleness I could tell she'd developed specifically for conversations like this one. I cannot tell you with certainty that these missed doses directly caused your wife's death, Judge Bennett. Patients with advanced Alzheimer's and underlying cardiac conditions are, unfortunately, at elevated risk, regardless of medication adherence. But I can tell you that consistent, undocumented gaps in cardiac and blood pressure medication over a period of months would have measurably increased her risk of a fatal cardiac event, and that if this pattern was deliberate, rather than simple facility negligence, it represents a profound, deliberate failure of care toward a woman who trusted the people around her to keep her safe. I want to tell you honestly that I do not know, to this day, with absolute certainty, whether Christine deliberately arranged for Maggie's medication to be mismanaged, or whether that particular horror was the result of understaffing and simple negligence at a facility Christine had nonetheless selected, continued using despite mounting red flags, and never,